Earlier today, a development inside Washington changed the legal conversation in a way courts, not commentators, will ultimately care about. Not because of a briefing, not because of a leak, but because a sealed matter moved from internal review into active posture. What matters now is not tonight's debate. What matters is what the record reflects, and how that record alters the entire document's case. This is not a story about boxes in a corridor. It is not a story about clutter, poor organization, or casual handling. Those explanations belong to an earlier phase. What surfaced today points somewhere else entirely. A sequence, a transfer, an exchange. In federal prosecutions, that distinction is decisive. When cases like this are evaluated, prosecutors do not begin with talking points. They begin with movement. Classified materials do not relocate on their own. They are logged, signed for, and handled by identifiable people at identifiable moments. That trail is known as the chain of custody, and in national security cases, it is foundational. This is where the widely accepted narrative begins to fracture. According to the record, a folder bearing the highest classification did not simply remain misplaced. It exited a controlled environment. There is a log entry. There is an acknowledgement. There is no dispute on that point. For a defined period, the document cannot be located where it lawfully belongs, not in an archive, not in a secure facility, not under authorized supervision. That absence matters, because gaps are where intent is evaluated. Public explanations have emphasized disorganization, personal effects, mixed materials, inadvertence. But disorganization does not explain destination, and it does not explain timing. The record shows that during the window when the document was unaccounted for, a private meeting took place. Not long after, not months later, within the same span. Then the record reflects something else. A secure communication was initiated. Shortly thereafter, funds moved. Not a routine payment, not an unrelated transaction, a transfer tied to a foreign account. This is the point at which negligence stops being a viable frame. Negligence does not produce coordination. In criminal analysis, isolated facts can mislead. Sequences rarely do. Material leaves custody. A meeting occurs. Money moves. That is not conjecture. That is pattern. And pattern is what courts assess. At this stage, the inquiry has shifted. The question is no longer whether classified material was improperly retained. That issue was addressed earlier. The question now is whether national defense information was conveyed. That change in framing alters everything. There is a legal gulf between mishandling and delivery, between obstruction and distribution, between carelessness and intent. That gulf is measured in decades. Under federal law governing national defense information, labels are not the centerpiece. Harm is. Knowledge is. Action is. The statute does not ask whether someone believed they had a right to possess the material. It asks whether the conduct endangered the United States. That is why this moment matters. The information at issue is not abstract. It is not historical. It is operational. In practical terms, it involves defensive capabilities, locations, systems, and protected identities whose exposure carries real-world risk. When such information leaves authorized control, the consequences are not political. They are operational. That is why these cases are approached with caution, and why reducing them to paperwork disputes misses the point entirely. If evidence shows that sensitive defense material became part of a negotiated exchange, the legal analysis changes immediately. Not rhetorically, statutorily. Distribution is not accidental. A transaction does not occur by mistake. People misfile documents. They over-retain records. They do not accidentally coordinate meetings, negotiate access, and receive payment. Those acts require intent. And intent is the dividing line between administrative violations and criminal offenses. Arguments grounded in authority alone do not resolve that divide. Prior office does not confer permission to deliver defense information. The law does not carve out exemptions based on status. It asks whether the conduct aided a foreign interest at the expense of national security. If that threshold is met, sentencing discretion narrows sharply. This is where many observers underestimate what is at stake. Obstruction statutes allow room for argument. They permit alternatives. They leave space. National defense statutes do not. Judges operate within frameworks designed for the most serious offenses against the state. Once those frameworks apply, outcomes are driven by the record, not by public sentiment. That is why today's development carries more weight than any headline. It suggests a transition from possession to exchange, from retention to transfer. And that transition reshapes not only potential penalties, but the historical meaning of the case. This is no longer about one individual's conduct in isolation. It is about whether national security can be treated as negotiable. The law exists to answer that question, and that answer is now being tested. What follows will not be decided on television or online. It will be decided by whether the evidence supports a single conclusion, that the conduct reflected a choice, not an error. And that is where the process now stands. From this point forward, the path is dictated by statute. Once credible allegations of transfer emerge, discretion gives way to obligation. The analysis becomes mandatory under some of the most severe provisions in federal criminal law. This is often misunderstood. Prosecutors do not select statutes for effect. They apply the statute that matches the conduct. And where conduct involves delivering defense information outside lawful channels, Congress has already defined the response. The law does not ask whether the defendant believed the act was lawful. It does not ask whether the material bore specific markings. It does not ask whether the individual once held power. It asks whether the information, by its nature, could harm the United States, and whether it was knowingly conveyed. That is the threshold, and once crossed, outcomes narrow. This is not an area of broad judicial flexibility. Congress constrained discretion deliberately, recognizing the stakes involved. Ambiguity is removed once intent and transfer are established. That is why investigations proceed methodically, because once this line is crossed, it cannot be uncrossed. At this stage, defenses that once carried weight begin to erode. Declassification does not authorize delivery. Personal authority does not permit exchange. Mistake does not explain coordination. In court, explanations must align with evidence, and evidence follows trails, not narratives. Here, the trail shows departure from controlled custody, a private interaction during that absence, and a financial movement closely thereafter. That sequence demands explanation, and explanations built on coincidence rarely withstand scrutiny. This is the point at which exposure is assessed, not simply whether charges could be brought, but whether they must be. Federal prosecutors are bound by principles requiring action when statutory elements are met. Declining to proceed under such circumstances raises institutional concerns of its own. That is why this moment is larger than any single defendant. It implicates the credibility of enforcement itself. If national defense laws bend for power, they fail for everyone else. The system cannot sustain that. By design, the process now becomes insulated from politics. Career professionals review decisions repeatedly, applying law rather than absorbing pressure. Grand juries evaluate probable cause. Judges assess sufficiency. Trial juries, if reached, weigh proof. Public reaction becomes irrelevant. Timelines matter here as well. National security cases do not move at the pace of news cycles. They move at the pace of verification. Records are authenticated, communications traced, witnesses corroborated. But when alignment occurs, momentum builds quietly and then decisively. That is what is being observed now. The shift from obstruction to potential transfer signals a belief that the evidentiary foundation is already substantial. It does not predetermine outcomes. It narrows the legal path. At that point, strategy yields to procedure. Courts do not ask whether prosecution is disruptive. They ask whether it is justified. And that answer is found in filings, not debates. The system was built for moments like this, not because they are common, but because they are dangerous. These statutes were written with the assumption that opportunity would eventually meet temptation. They were designed to ensure that no individual could convert national defense into private currency. That principle is now under examination. If the evidence supports transfer, the consequences are severe by design, not as retribution, but as deterrence. Because once defense information becomes negotiable, vulnerability follows. That is why these cases are treated differently, why sentencing frameworks are rigid, why leniency is rare. It is not vengeance, it is protection. The process will continue, quietly. Motions will be filed, evidence tested, rulings issued. And if the statute applies, the outcome will follow the law, not opinion. That is how the system is meant to function. What remains unresolved is not the seriousness of the matter. That is already evident. What remains unresolved is whether the evidence will meet the final burden required to sustain the most consequential charge available. That answer will come from proof. And until that proof is weighed, the only responsible course is to allow the process to run, fully, transparently, and without exception. Because if the law cannot operate here, it cannot operate anywhere. That is the question now before the system.